Hello, this is David Olshan of Nevada Legal Services. This is another in our series of substantive law videos regarding bankruptcy and specifically the debts that survive bankruptcy. Non-dischargeable debts that apply in both Chapter 7 and Chapter 13. This is by operation of law, meaning the creditor doesn't have to do anything. We're talking about alimony and child support debts. Student loans are not dischargeable. You may file an adversary action and get those discharged, but a judge has to agree, and you have to file an affirmative complaint. Tax debt is usually not discharged. However, if the tax is owed for more than 3 years on a return filed more than 2 years ago and the IRS has tried to collect it for 240 days, that tax debt will be discharged. Debts created out of a DUI resulting in death or injury, that's not discharged. And any debt that was previously found not dischargeable is also not dischargeable, meaning if a court found it was not dischargeable in an earlier case, it's not dischargeable in your new case. Also, some of the debt, like alimony debt, wouldn't be dischargeable either. So, debt that you list that has received no objection, this may be discharged in a bankruptcy. You're basically crossing your fingers and hoping for the best. Debts created by fraud, they could be discharged unless the creditor files an adversary action. Debts for luxury goods, and that's defined as spending $725 within 90 days of filing your bankruptcy, or cash advances of over $1,000 taken within 70 days of filing your bankruptcy. Those can be avoided. That money can be returned if the creditor objects or the trustee objects. So you will not get away with that if somebody objects, but if nobody objects, that debt will be discharged. Debts for willful or malicious injuries to the property or person, those will also be discharged unless somebody objects, files an adversary complaint. Debts created by embezzlement, larceny, and breach of fiduciary trust, those are also discharged unless somebody files something. So it's not by operation of law. The creditor or the trustee has to do something. And what that means is if nobody does anything, you can, in essence, get away with it. We want to talk also about debts that are discharged in a Chapter 13 and not in a Chapter 7. So divorce decree debt, and I'm not talking about alimony or child support, I'm just talking about a debt created in a divorce decree that is discharged in a Chapter 13. Debts include, sometimes you can pay off a tax debt with a loan. That debt can be discharged in a Chapter 13. Court fees can be discharged in a Chapter 13. Condo, co-op, or HOA fees, post-petition. So if you file those fees that accrue after you file a Chapter 13, those are discharged. Debts, sometimes you take a loan from your 401k and those debts can be discharged in a Chapter 13. Debts that couldn't be discharged in a previous bankruptcy, what's known as a Chapter 20, where you file a Chapter 7 first and then you try to strip the mortgage in a Chapter 13, that's a debt that couldn't be discharged in a previous bankruptcy and it can be discharged in a Chapter 13. And of course, a cram down where you have a car loan and you reduce the loan to the amount of value in the collateral, that basically is not allowed in a Chapter 7, but it is allowed in a Chapter 13. And fines, penalties, and forfeitures owed to a government, if they're not criminally related, those can be discharged in a Chapter 13. We can help you with your bankruptcy, whether it's Chapter 7 or Chapter 13. Give us a call in Southern Nevada, dial 866-432-0404. In Reno or Northern Nevada, 800-323-8666. We provide free legal assistance, and I will be back with more substantive law videos in the near future.